Fuller here. Berryhill. Corbett. Corbett here. De Leon. De Leon here. Desaulniers. Desaulniers here. Emerson. Emerson here. Kehoe. Kehoe here. Pavley. Rubio. Rubio here. Simidian. Strickland. Wright. Right here.
Okay, a quorum is present. We now turn to AB 1073. Assemblymember Fuentes.
Thank you, Mr. Chair. Senators, Assembly Bill 1073 is a cleanup measure that clarifies an ambiguity, can you help me with that word? Ambiguity contained in last year's SB 226 that ensures that an estimated 200 to 300 jobs will not disappear. The enabling legislation by Senator Simidian, SB 226, authorized a small group of solar projects that were certified by the California Energy Commission after August 15th of 2007 to petition the Commission for an amendment to their certificate if they switch their technology from solar thermal to solar photovoltaic. As the Governor stated in his signing message, the bill allowed the Commission to streamline worthy projects and avoid costly and repetitive permitting for certain renewable projects. SB 226, among other provisions, barred projects that were challenged in court from seeking such an amendment to their certificate. However, a letter to the Senate Journal dated September 9th of 2011 stated that it was not the intent of the bill to bar projects that were challenged but subsequently dismissed by the California Supreme Court. This bill would clarify that point in statute, taking the same language from the letter itself to ensure that there is no ambiguity. AB 1073 also clarifies that nothing in the new law abrogates a party's right to challenge projects going forward. For these reasons, I respectfully ask for your aye vote. Today I'm joined by Ms. Delaney Hunter and Mr. Scott Wedge, who would like to testify in support of the measure.
Mr. Chairman, I am not Delaney Hunter, but I'm here to testify.
Mr. Wedge, how you've changed.
Here on behalf of K-Road Calico Solar to speak in support of the bill. The SB 226 was amended on the evening before the last day of session last year, and language was added that allowed certain limited number of solar thermal projects who had gone through the entire environmental evaluation certification process at the California Energy Commission to be able to switch their technology to photovoltaic and to go back to the Energy Commission, who has all the knowledge and understanding of the project, to modify the project documents and the environmental analysis to allow the project to go forward as a PV project. As you're probably aware, PV projects are becoming almost at grid parity in terms of the pricing. Moving from solar thermal to PV not only has ratepayer benefits, but it has environmental benefits as the projects have less environmental impact and create significant amount of new jobs. Unfortunately, there was language in the bill that unintentionally precluded K-Road Calico's project from going back to the Energy Commission. And that language was on the last page of SB 226, and it basically said that this section shall not apply to the project if the project's certificate was timely challenged. What it didn't address was that what if the challenge was timely, but the court dismissed the case. And that's what Senator Simidian's letter to the Journal, which we passed out to you, you all have. Senator Simidian's letter to the Journal promised cleanup legislation this year and basically said it was not the intent to deny a project who would otherwise be eligible to qualify for SB 226 if the certificate was challenged and, I quote, subsequently dismissed by the California Supreme Court. So that's the reason we're here today. We're aware an amendment has been offered that we view as getting into a policy area and dispute that doesn't involve this project, a much larger issue that could result in a veto of this cleanup bill. We don't want to obviously endanger this bill in any way. This is purely a cleanup bill. It was agreed to by the Governor's office, Senator Simidian and others, and we would like to limit this bill to that subject area. Thank you and ask for your support.
Thank you. Any other witnesses?
Mr. Chairman and members, Scott Wetch on behalf of the State Association of Electrical Workers and the California Coalition of Utility Employees. We were involved and supported Senate Bill 226, although we were disappointed at the time that the Calico project wasn't included. Now that the Supreme Court dismissed the case, we really see this as a win-win. This project will employ at the peak upwards of 400 construction workers at a time when we desperately need those jobs. It seems nothing in the bill gives a break to a thorough and rigorous review of the project, but the fact remains that shifting technologies actually reduces impacts significantly, and therefore we think the CEC, who's most familiar with the project, is the appropriate location to help expedite this project so we can get the California back to work. Thank you.
Thank you. Next witness, please.
Good afternoon, Mr. Chairman and members. Robin Smutney-Jones with the California Energy Commission. The Energy Commission is here in support of this measure today, and I have some witnesses here that can help respond to questions if need be.
Well, since you're here, let me ask you a question. Reference was made to, I don't know who, but somebody pursuing amending language to this greater issue. I think there's one that's outlined in the analysis of whether or not CEC has the authority to make this determination on being the lead on the environmental review for the various technologies or not, or if there's legislative clarification that's required or not. Is there a comment on behalf of the Commission?
Are you referring to the Ridgecrest proposed decision?
Well, that's that decision, but this is a different project that's the subject of this legislation, but people have made reference to the Ridgecrest decision and the greater policy question.
So what I would say, and I'm happy to bring my attorney up here if you need, the Energy Commission does not believe that Ridgecrest or those jurisdiction issues are connected with this measure.
Well, I would personally agree, but there's others who view differently and are raising it in this conversation. So that's why I ask.
Okay. We don't think there's a connection. If there are questions about any of those issues, I'd like to bring Mr. Levy up.
Okay. Well, let's see if the conversation takes us there. Let's finish testimony here in support. Anybody else in support?
Mr. Chairman, I just, with me is Sean Gallagher from Cairo Calico to answer any questions about the project.
Okay. If there's no other witnesses in support, let's call forward witnesses in opposition. Who gets to go first?
I think that would be me. Good afternoon. Thank you very much. My name is Kim Delfino, and I'm the California Program Director with Defenders of Wildlife. As a little background, my organization has been working for the last 3.5 years on trying to encourage strong siting policies so that we can get renewable energy projects on the ground as quickly as possible. We've been working at the state and the federal level, coming up with some, I think, novel ways of trying to do that. And including working directly with the companies themselves to help them when they may not have chosen a best site. Unfortunately, with this particular project, the Calico project, which is the project at issue with this bill, because this bill really is only directed at one project, despite best efforts, there comes a point where it does come down to location, and this project is located in a very bad location, the Pisgah Valley, which I think the Nature Conservancy can speak to, given they've done a lot of scientific reviews about this, is a really important area from a biological perspective for desert tortoise survival and conservation. Fish and Wildlife Service has identified it as critical. No matter what we do with this project, it's still in a bad location. So I would just take a step back and say that the characterization of the SB 226 as inadvertently omitting the Calico project from the exemption that was written in. It wasn't inadvertent at all. That language was written very specifically in a way to exclude 3 projects, one of which was the Calico project. That is why And the reason, and because the language was written so specifically to exclude the Calico project back when SB 226 was moving, our organizations took a neutral position on that bill. Now that Calico is coming back before you to go back to the Energy Commission as a PV project, we are opposing this project, which is completely consistent with our position from last year. So we would urge a no vote, one, because we believe this project is chosen poorly and we don't think we should be encouraging special exemptions for projects like this. Two, and which was referred to already by the chair here, we believe that running this bill again, given the uncertainty that's been created around the Energy Commission's jurisdiction, this bill raises a real question in our mind about how we're construing the Energy Commission's jurisdiction. The reason I say that is because when SB 226 was passed, everyone thought the reason why we needed to do that provision for those projects is because the Energy Commission didn't have jurisdiction over PV projects. Otherwise, why would you even need the bill? Unfortunately, the Energy Commission issued a proposed decision in December after SB 226 was passed, and in its decision, it said that the CEC stated in its decision that, quote, even assuming that the legislature did not initially envision that the Energy Commission's role in implementing statewide siting policy as encompassing non-thermal power plants, the legislature's October 2011 passage of Senate Bill 226 makes it plain that the legislature now has such a vision. Now, the counties have, and I think they will say, have real concerns about this, including and the environmental groups. With AB 1073 now moving through the process again, it raises this issue. If SB 226 was construed self-servingly, I would say, by the Energy Commission to justify jurisdiction over PV projects, what is AB 1073 going to do? Since they haven't actually finalized this decision yet, and this is very much an open issue. So for all of these reasons, our organization strongly urge a no vote on this bill. Thank you.
Thank you. Next witness, please.
Chair Padilla, committee members, my name is Jim Metropolis, representing Sierra Club, California. We are also opposed to AB 1073. The Sierra Club was the organization that challenged the certification at the California Supreme Court on the Calico project. I'd just like to add that there was no decision on the merits of our case. The Supreme Court just chose not to hear our challenge, and that's because the California Supreme Court is the only court or the only place to appeal certifications of energy projects from the Energy Commission. There's no appeal to a superior court. There's no appeal to the Court of Appeals. It's only an appeal to the California Supreme Court. No, the California Supreme Court has never accepted and heard a case on a challenge to certification at the CEC. And so while that challenge was not heard, we don't have a lot of faith in the CEC expanding their jurisdiction over projects like PV solar, hydroelectric, and wind projects. And so we don't believe that the CEC should step in the place of the Department of Fish and Game, in the place of the regional water boards, and in the place of the local jurisdictions where these projects are sited. So we're asking you to oppose AB 1073, and I think we do need to clarify where exactly the CEC has jurisdiction on what type of projects. Thank you.
Thank you. Other witnesses? Briefly.
Good afternoon, Chair and members. My name is Pablo Garza with the Nature Conservancy, also here in opposition. And I say, as already referenced, our chief concern with this bill is the location. And we're afraid that the reduced environmental review that will result from this legislation is going to undermine the ecological integrity of the site where the Calico project is proposed to be. And we know from an assessment that the Nature Conservancy did that this location provides high-quality habitat for a variety of declining and threatened species. And this assessment was completed in fall of 2010. We call it the Mojave Desert Ecoregional Assessment. I know it's a really original name, but it's based on numerous federal and state sources, 50 expert interviews, and a sophisticated GIS analysis. And about 3/4 of the Calico project is located on area that was deemed ecologically core as per this assessment. And there was prior efforts, as already mentioned, to change the location or the siting of this project, and that's unsuccessful. So, the bottom line is we're afraid of the significant adverse impacts this is going to have on biodiversity in that location. And I'll note that we support the state's efforts to push to generate more electricity from renewable sources. We support the RPS. We even supported Senate Bill 226 last year for a variety of the provisions in it, even allowing the other 7 projects already discussed to move forward. However, when it comes to citing renewable energy, location is very critical. We think it's important to try and minimize ecological impacts, and for that reason, we're opposed to AB 1073 and urge your no vote. Thank you.
Thank you. Next witness, please.
Kara Martinson on behalf of the California State Association of Counties. We are still in the process of vetting this bill with our membership, and we don't have an official position on the bill. However, I did want to voice our concern, as mentioned, about the trend we are seeing to circumvent the local permitting process for the siting of PV projects. As with Senate Bill 226, we are very concerned about the precedent-setting nature of these bills and the potential for more requests to go to the Energy Commission, thus circumventing the local permitting process. We do see the local process as the appropriate channel for these discussions to take place regarding the merits and the impacts of these projects, and just wanted to raise that concern with the committee. Thank you.
Thank you.
Tim Lynch on behalf of the San Bernardino County Board of Supervisors. We also do not have a position on this bill, and in fact, we're on record supporting the jobs and the economic development that come with it, and we don't disagree with the sponsors on that point. We also just wanted to highlight the tension that this type of activity creates between the local level and what's going on at the Energy Commission, and wanted to express that today.
Okay. Other witnesses in opposition? Seeing none, let me afford the author an opportunity to respond to any of the issues that have come up.
Thank you, Mr. Chair. It sounds as if there's a tremendous amount of concern and issue with the potential in the proposed decision as it relates to sort of jurisdiction, whether the CEC should or should not exert itself or provide that opportunity for these projects. I think that's a very important policy conversation, but I'd like to remind folks that this bill doesn't speak to that debate, and depending on what the CEC does in the future, maybe we ought to consider trying to limit or permit the CEC from exerting their ability in jurisdiction. This measure simply tries to memorialize Senator Simitian's bill, and in particular the letter of intent in the file as it relates to this particular issue. So understanding that there's concern about that, I would remind also the opponents of the measure that there is plenty of opportunities for environmental review, whether it's at the CEC or at the local level. And again, I think that's an important thing to remember here. We aren't circumventing or asking for an exemption from that very important review. As a result, what this bill would do is it would facilitate the continued part of the project as it relates to the conversion from thermal to photovoltaic, and understanding that the CEC has by and large owned the issue in the area, it seems like it would make an awful lot of sense to permit that to continue. So with that being said, I would respectfully ask you for an aye vote as well as your Senate colleagues.
Okay, thank you, and I appreciate you acknowledging the proposed decision, and that it's a valid conversation, but can be, should be had and resolved separate from the consideration of this bill, my opinion as the chair. The other is, in some people's mind, a major distinction, in other people's mind, maybe a minor distinction, but who's the lead on the environmental review is a different question than is there going to be an environmental review? And for folks who I heard directly and indirectly concerns and arguments about the Energy Commission being the lead on an environmental review because of whether the quality of the review that's going to take place or the capacity or whatnot. The way CEQA is in place, people will have recourse to challenge an environmental review that they don't feel is up to snuff, to use a technical term. So that gives me a comfort level to make sure that we're not undermining any environmental protections that we have in the state. And to me, it kind of narrows it down more to, is it happening at the local level or at the state level? But there's public comment, there's, I don't encourage litigation, but if people feel it necessary, there's that alternative at some point along the way as well. Members of the committee with questions, Senator Rubio, Kehoe, and then Pavley.
I have a question for the CEC if they can come back up by chance. Thanks for joining us. This additional workload that your commission will take on, could the legislature anticipate a budget change request of some sort? Are you going to have to ramp up your staff to meet now these new applicants, or do you feel as though you can fold it within your existing capacity?
Senator, are you speaking about Calico in particular or all the 226 projects?
This would fall under the 226 umbrella.
Okay. Let me introduce Roger Johnson, who is the Director of Siting at the Energy Commission, and he would be best qualified to answer that.
Thank you, Senator. The Commission does not anticipate the need for a BCP or additional resources to process this amendment. The Calico project had already filed an amendment with us to change the project to part PV and part thermal, and we began work on that amendment. That's been put in suspension now, pending the outcome of the decision to go forward with the project. But we have the resources to process this amendment.
Good. I was hoping that because we've done some work in the past, you and I, not particularly, but where we try to move a body of work to only then find that you're having to significantly wrap up at the cost of those who are trying to move their project to you. So that's refreshing. The second part to me isn't so much who does the review. Is it the lead agency at the local level or the CEC? Could you speak to the challenging part? So if I, as a citizen, want to challenge a project that you are the lead agency, what's the process and how does it differ between a project that's before the CEC and a project that, say, is before one of the 58 counties in the state?
And now I'm going to introduce Mr. Michael Levy, our General Counsel.
Thank you.
Good afternoon, Senator and members of the committee. The Energy Commission certificate operates in lieu of every local, regional, and state permit. And so the mechanism to challenge a certificate of the Energy Commission is to file a petition for writ of mandate with the California Supreme Court. This is similar to the historical process that we used for the Public Utilities Commission, though now there's a writ of review to the Court of Appeal as well.
And that is significantly different than if I were to challenge under CEQA at the local level. Would you agree?
That is significantly different. It does expedite the review. It allows all of the challenges to be brought in one forum at one time, and it allows certainty for the project applicants who don't need to wait 10 years to see if their project's going to go forward.
Thank you very much, because you just hit the word that I think summarizes and why I'm going to strongly support this particular bill, is that it provides certainty in the process. Much like we did for a basketball arena in downtown Sacramento or a football arena in Los Angeles, we're trying to provide certainty in this particular arena, and that's why the shift is occurring. So notwithstanding the issue that needs to be resolved, though, this is leaving a very large discussion that has to be wrestled with in this building, and that is the issue of jurisdiction, because some counties have done a very good job under CEQA, primarily Kern County, if I could toot their horn for a second. They've done a fantastic job, and so I know applicants who would like a choice whether to go through the local jurisdiction, that being a county, or going before the CEC. But what would work best for that particular applicant in providing the greatest level of certainty, I think, is an issue that should be discussed. And I'm pleased that many of you who have approached us have said that that's something that we still need to resolve. And I appreciate the chair's perspective, and I'd like to move on the bill, in fact, to move this forward, because it continues the effort to bring certainty in an area where, on one hand, we say we want 33% and we want renewable energy, and how we're going to partner then with the private sector to site, permit, and construct those projects. So I want to thank you for bringing this forward.
Thank you. I'll recognize it as a motion, but we still have members with questions and comments. Senator Kehoe.
Thank you. Thank you, Mr. Chairman. I'd like to hear from the opponents again. I have some questions. Maybe Mr. Metropolis and Ms. Delfino, are they still here? In your In your joint letter, you said that most of the signers didn't object to last year's 226. So why are you objecting? And my understanding then was that Mr. Simidian's intention was, if there is a court case on one of the projects, that would not be addressed in 226. Now, my understanding is the court case against Calico has been resolved at the state Supreme Court.
Right.
And so why are you opposed to the bill now, since the suit has been resolved?
Well, the suit was resolved before SB 226 was even drafted.
Okay.
So it wasn't like SB 226 was drafted a certain way, and the Sierra Club had a petition pending before the Supreme Court, and then it was dismissed. That had all been said and done months prior to even the drafting of the one section to SB 226. So again,
What's your understanding of why Calico wasn't included in 226 then, if the suit had been resolved?
Because the environmental community strongly objected to the Calico project, and that we said we were going to object to we were going to take an opposed position on SB 226 if Calico was included, and therefore it was drafted in the way that it was drafted to specifically exclude the Calico project. It wasn't until the last couple of hours, frankly, before session, where it sort of all...
And is it the change from solar thermal to solar that's your objection? Did the size or scope of the project change?
No.
What, the location?
Right.
Okay, tell me what your objections are.
Our objection to the project from the very beginning has been, the fundamental objection has been the location, which was an unfortunate location. Like I said, there's
This is the place that was
Pisgah
identified
Valley.
as special habitat?
Right, the Pisgah Valley.
Yeah.
And we had been on record, and we'd been meeting with the company for almost 3 years, talking this over. In fact, the environmental community, when the first big set of projects came out into the desert, decided that we would start talking to the companies right up front and try to work out our differences, because we strongly wanted to move forward renewable energy projects, despite they were very controversial within the environmental community. We managed to work out agreements on a number of projects. First Solar's Desert Sunlight Project, the Genesis Project, which has since run into problems but because of cultural issues, to Sarah's Imperial Valley Project, Solar Millennium's Blythe Project, Solar Millennium's Palin Project. But this one, we were not able to reach any agreement because we were asking that the project be moved because of the sensitive nature of the Pisgah Valley. So we've been objecting to the project because of its location from the beginning. We also have other issues, like, for example, we don't believe that the Energy Commission has done a very good job of doing environmental review. They stand in the shoes of every agency. They issue an in lieu permit for Fish and Game, for the local air district, for the water board, and frankly, we haven't seen the greatest attention to the issues that we are concerned about at the commission level. And so that's the reason why we weren't excited about projects that we didn't like going back through yet again, now in PV form. Plus, we had concerns about this issue of jurisdiction over photovoltaic projects to begin with. So we were trying very hard to sort of be good soldiers in the effort to meet RPS, stand aside and let the bill go through because it was allowing certain projects we were able to work issues out on. And that was because we thought that 3 projects, Ridgecrest, Palin, and I guess we didn't reach out agreement on Palin, but Ridgecrest, Palin, and Calico were the 3 projects that were specifically written out of the bill.
Okay, thank you.
I just want to add that the Sierra Club was opposed to SB 226, and this is being opposed to AB 1073 is consistent with that position.
Senator Keogh, could I clarify a few issues on the process?
With the chairman's okay, sure.
Yeah, Mr. Chairman.
If it would be helpful to you, Senator Kehoe.
Yes, please.
The couple things. First, on the comment on the CEC permitting process, it's rather ironic. We represent First Solar and other solar developers. If you ask any PV developer in the state, they will almost unanimously tell you they prefer going through the local process. As a matter of fact, the Large-Scale Solar Alliance opposed language in the RPS bill that would have allowed an option to go to the CEC because it is costly, lengthy, and difficult, far more difficult, to go through the CEC permitting process as a reality, and takes more time. What you get at the end of that, though, is you get to go to the California Supreme Court. But if you ask PV developers, I think every single one will tell you they'd still rather go through the local permitting process because there's less obstacles. That's one. So the notion that the CEC process is somehow a giveaway is the furthest thing from the truth. Second, the reason that Senator Simitian did the letter to the Journal is the bill was amended on the second to last night of session. We tried to get the language fixed in the Assembly. We were asked by the governor's office and Senator Simitian not to fix it because it was the last day of session and they were afraid the bill would not get to the governor then. So we reached an agreement. Senator Simitian clarified through his letter, which I read to the committee. It's very clear. The governor's office is in agreement that this was a technical issue. It should have been fixed. It wasn't because it was the provision in the bill was a gut and amend on the last or second to last day of session. And so that's how we got here, and I just wanted to clarify that. Thank you.
Thank you.
I would make one note. With all due respect to Mr. Manning, in the 3+ years I've been dealing with the solar industry, I would say that they are not a monolith. I think different companies have different positions and opinions about what process works better for which company. So I would just say I don't think it's necessarily true that all PV projects think they don't want to go back to the Energy Commission. And I would just simply respectfully say on his last point, I think there was just a very big difference of opinion on sort of how things came together in the last hours of session.
It gets like that sometimes. I guess I would say, Mr. Chairman, whether the developer wants a local process or a CEC process or expedited or whatever. One of the questions is the CEC doing it right? When they do it, if they do it, are they doing it right? And there seems to be some discrepancy about that. And the bill's a one-project bill, which always raises a few extra questions. And I understand, I think, why you want to do it. We all want to see solar developed in California. A few years ago, it seemed as though it was going to be the big green go button, and now we realize it's far more complicated. And we're also having two parallel discussions, as we sometimes do here. We've got the court case discussion, let's say, and then the project discussion itself. I didn't understand that the court case had been resolved before 226 went through. So the bill this bill before us today isn't fixing that problem. It was already done. Right. I just would say I would be far more comfortable if it was going to environmental quality or natural resources where we could look at some of these other issues. But the way it's set up right now, I'm just not comfortable with an aye vote. I'd also like to say we're in the second week of March. I mean, is there a way to look at this a little bit longer and still move it through in an expedited fashion?
Yeah, well, we depend on the author and the votes today.
There is a reason for the urgency, Mr. Chair, and we'll have Mr. Anning who will be far more eloquent than me in explaining it, but there's a June 10th deadline, June 30th deadline. Mr. Manning?
To reapply to the Energy Commission. And just to be clear, Senator Keogh, the issues that were raised on habitat, and it's primarily desert tortoise habitat, we've shrunk the project down, but we have to get permits, just like we have to go through the CEC process. And when we go back to the CEC, we can be sued again. If the folks who don't like this bill because they want to kill this bill because they don't like the desert tortoise mitigation, they can sue us multiple times in multiple jurisdictions. All this bill does is allow us to go back to the CEC, amend our environmental documents so we don't have to start over at the local level. Start the permitting process over. And if we don't get an urgency bill quickly, we will miss the deadline to reapply to CEC. That's the problem we have.
So, Senator Kehoe, to your point about the parallel conversations, I agree, and I tried to highlight that distinction in my earlier comments. I don't think we should be in the business of hearing specifics of a project and certifying EIRs in this committee. We are speaking to process, and currently, whether people like it or don't like it, there are some environmental reviews that are conducted at a local government level, some at a state level, and in some cases there's the options of where to take your environmental review. That sort of is what before us. The substance, quality, and merit of the outcome of that environmental process by whoever at the local or state level is a conversation. But, again, that's not what's before us today, I don't think, nor should it be. Senator Pavley, Senator Corbett, and then Senator De Leon.
Yes, I appreciate the discussion and, obtained all this over the weekend because I guess the report came out on Friday, so I apologize for a few of these questions I've not paid attention enough to be a detailed review on them. It's my understanding, is it only benefit one company? Is that correct or not? One project, Calico Solar.
The amendment, as we saw it, only affected K-Road's project.
Okay, and that's the Calico's
Correct.
Solar one.
Correct.
Okay, which always raises some antennas there. But my understanding was, and this is where it gets difficult the last few weeks of session, where when you're negotiating and compromising with different groups in order to get a bill passed through the legislature, people make representations where you feel that there was an agreement, and that's why perhaps some organizations took a support position or some didn't based on those representations. So I have concerns on just how we do business in this House, because I've been on the receiving end where people have represented to me that, oh, it's getting late, and if we promise that if you pass this, then we will look favorably on, it had to do with water rights. We'll look favorably on that, and everyone agreed, absolutely, no problem, we're there, and then that comes undone. So it matters when you negotiate a deal, as you can. Also, I just wanted to say for the record, Kim Delfino with Defenders of Wildlife is probably one of the most reasonable, thoughtful people relating to siting of renewable energy in the desert. I'm a huge proponent of renewables and ramping up to make our 33% portfolio standard required under AB 32. And the solar companies are doing a magnificent job, and she, as well as others, have been in the midst of that, trying to assist with siting and make sure that there are parameters around it so that we minimize litigation and potential conflict. So I'm a little concerned when the counties came up and other people that there's going to be some growing tension relating to locals versus the CEC, which could end up into unintended consequences on litigation regarding the siting process. And locals can be obviously as big a problem as a state agency, but making sure that there is a standard and non-arbitrary environmental review, whomever it is important. So I guess I need an answer to a question. Does this circumvent local siting processes by going to the CEC? Maybe Mr. Fuentes, you could answer that.
No, I will share the answer with Mr. Manning. No, it doesn't. I mean, I think what's important here is that you have the same process and the ability to seek redress in either situation. And I understand why the opponents of the bill would not like this particular site, given sort of the challenges that they believe exist. But it doesn't. This bill wouldn't change their ability to try to exert their ability to seek redress in any way. And it's not about changing venue here. I understand there's a lot of concern about what the CEC is proposing in its proposed decision, but we're not trying to ratify that or debate that here, and would hopefully ask the senators to sort of just pay attention to what it is that we are doing here, which is trying to memorialize the intent as stated by Senator Simitian in his letter to the Journal, in the, again, not perfect making of legislation last year, but in his, I think, smart view that there was something missing, and what this bill would do is would codify that. And so I would be just as circumspect as you if we were coming in here with a measure that out of the blue tried to change something that somebody didn't like, but this is a continuation of last year's work.
But the opposition for this particular project, which they thought was addressed in 226, is still out there, and so by
and the opposition had an opportunity to sort of see that redress, and the state Supreme Court did not grant writ. So I would argue that there's been opportunities afforded to the opposition as well in trying to look at this particular project. What we're trying to do here is memorialize the process that Senator
That was
Simitian,
not on the merit. It's quick. They've never reviewed a CEC project, and so I am concerned, about the long term, not just this project, but the long term sort of tension and ability or perception by local reviewing authorities that they can sort of get a pass, if you will, coming up through up to Sacramento, and it's something that may not be in the long-term best interest of the solar industry as a whole. I don't know this particular project. I'm just some red flags were raised today that make it maybe problematic in the long term in more opposition locally to projects, or at the end of the line coming up here through Congress. So it may not help the industry as a whole as we ramp up to meet that. And Senator Padilla, you outlined the other question on just the ongoing debate on jurisdiction, whether the CEC has full permitting over PV projects. And so if this bill moves forward, anything you can do to narrow that down to just limited class of PVs, and what would possibly go through? Because are we establishing precedent here today, even though this is one project, that we're opening up some unintended consequences?
I would argue that we are not establishing precedent here. This, again, memorializes Senator Simitian's letter to the Journal, but I absolutely appreciate the concern that you shared, and I think a future debate ought to be had about who ought to have jurisdiction and who should not. And again, I don't want to confuse that conversation that's being talked about the CEC and in their proposed decision affect this measure here, because I think it is important to figure out who should and who shouldn't assert jurisdiction. And I would just take a small exception to the point that there's an agency that would give you a pass on citing or permitting these, I think, very important projects. You said that the state might give you a pass. Again, my experience as a previous chair to a very similar-minded committee is that
if your only ability to legally engage after the approval process is to go up to the U.S. Supreme Court, State Supreme Court, to just decide whether they're going to hear it or not, and procedurally they do not, it sounds like, there's sort of an issue there. So I just wanted to set for the record that there's, we're treading in some fine lines. And I'm a huge advocate of not only the solar projects, but also I think the CEC does an amazing job. I have not known them in the past to have a strong environmental review procedure. I'm sure they will be capable of doing that. But thank you for allowing me to ask some questions.
Thank you. Senator Corbett, followed by Senator De Leon and Senator Wright.
Thank you, Mr. Chair, and I'm glad we're here today to try to figure out what we can do to continue to meet our goals. And I know that we're right at the center of this in this discussion. A couple of questions. Do we know, has Senator Simitian weighed in on this? Do we know of his support or opposition to this measure? Do we know the answer to that question?
I have not personally had a conversation with him, but again, his letter intent reads identical to this measure here. But is he still a member of this committee? I'd ask you all.
We have
heard from him.
Yeah, I mean, I'm not going to say what Senator Simitian's position is because he's not here. But I would say that, no, I would not. But we did talk to Senator Simitian. We worked with Mr. Pester on the drafting of the language, and the only thing I can tell you is Senator Simitian said that this language in this bill accurately reflects exactly what was in his letter. And in his letter, he said, to the extent there is any ambiguity about the intent of this provision, I will pursue clarity through additional legislation at the earliest opportunity. So that's what we're trying to do.
Okay, thank you.
Yeah.
And then my other question is, and Mr. Manning, you alluded to this, that there was an amendment that was offered by the opposition. And I just got this last minute today, too. I was just wondering if the opposition could sort of weigh in on this, explain the amendment to us, and then have an opportunity to respond by Mr. Manning as to why he believes maybe it doesn't work. We really haven't fleshed that out yet. So there was an amendment offered, and I understand that some of the opposition might be removed by it, but I understand there might be some problems with it. So if we could just hear a little bit more about that, I'd appreciate it.
Right. Well, it comes down to this issue of jurisdiction and the fact that when SB 226 was discussed and enacted last year, it was with the understanding that this was a narrow exception being made for a small class of projects that were converting to photovoltaic for a variety of different reasons, and that they needed to go back to the Energy Commission rapidly in order to meet their ARA funding deadlines. They were getting federal loan guarantees that required their all environmental permits or all permits to be done by the end of 2011. So, which, by the way, this project is not in that category because they don't have a DOE loan guarantee. But so when that was enacted, the environmental groups were very surprised, I think the counties were as well, to see then a December pending decision by the Energy Commission that then cited SB 226 as specifically standing for legislative intent for giving them, saying that they have jurisdiction now over non-thermal projects, including photovoltaics, which was never our intent, because why would you ever even need SB 226's provision if we all assumed the Energy Commission had jurisdiction over PV projects? They simply would just go back to the Energy Commission. The concern is that with AB 1073 now coming before the Energy Commission, after the proposed decision is now sitting out there with an interpretation of legislative intent, and this bill moves without saying anything about that, whether it's correct or not correct, that somehow validates the Energy Commission's interpretation of SB 226 and the legislature's intent regarding their jurisdiction on PV projects. So we thought that we could try to address this issue, which was raised back when 226 was enacted and the way the Energy Commission interprets it, that maybe at least we could try to get this issue dealt with. And if we could, then we would, withdraw. Some of our organizations would withdraw our opposition. Sierra Club, I think, I don't think that they would, but Jim can speak for himself. But that was the idea. Now, obviously, this issue is, evolved, and there's an argument about there being two separate issues and how we're going to deal with jurisdiction later. But that was the thought process behind raising this particular suggested amendment.
Okay, thank you. And why do we believe this amendment won't work?
I'm not clear if I think I know what the proposed amendment is, but if you could just let us know what I know that you just gave us the context. What is your proposed amendment?
The amendment essentially was going to add a section at the end of 225.500.1 that would say something along the lines of, because I can't remember the exact language, that it's not this provision is not intended to be construed as the Energy Commission having jurisdiction over photovoltaics, wind, and hydro projects. Essentially, it was clarifying something somehow that the Energy Commission was unclear upon, and that is SB 226 somehow was an intent, when that provision, 225.500.1 was added, that somehow the legislature was signaling that suddenly now the Energy Commission had jurisdiction over non-thermal projects. That was all.
First of all, my understanding was there was only one of the many opponents who would pull their opposition, that was defenders. Second, the language goes to exactly this broader issue. Right now, we know the administration is supportive of this bill. We've talked to them. They were involved in the letter to the Journal last year. We drafted the language very narrowly to reflect exactly what's in Senator Simitian's letter to the Journal. We don't know whether the language Ms. Delfino is suggesting would get vetoed, but it does raise a possibility that the governor's office will not look kindly on the bill. And therefore, all we're trying to do is fix an error from last year and not get into this broader debate, which could make this bill veto bait.
So you do believe the amendment would mean a veto?
We're not sure, but we certainly don't want to take the chance, especially since the administration has said they do support this bill as drafted.
Okay.
But I think there's a larger discussion, Senator Corbett.
Senator Corbett, if I may, on the one hand, I hear the concern. Unless you say this in the language of this bill, it could be construed or interpreted as the legislature somehow condoning or agreeing that the Energy Commission believes they have this authority. But by virtue of the fact that we have this legislation, both 226 before us, previously, and the bill before us, I think the legislature, through its actions, if not through its words, through its actions, is reiterating we need legislation to allow for the Energy Commission to be the lead on the environmental review for X, Y, or Z. So, the other side of the coin is also present. People can construe it or interpret via our actions that the legislature believes otherwise. I still think it's an important question to clarify and resolve in, I think, a separate piece of legislation or venue.
Yes. Just trying to see if there was something that could be worked out on the amendment.
Senator Corbett, let me also affirm the fact...
Might be room for discussion, I don't know.
Let me also affirm the fact that I've had conversations with the governor's office as well, and while they never tell you whether they'll veto or not something, I've had strong urging that the language as drafted is exactly the way they'd like to see it.
Okay, I appreciate that. And then one last question with regard to the timeline. I understand there's some urgency. Does that mean it must pass today, or there would be time for more discussion? I'm just trying to feel out how much time you have, Mr. Manning.
Yeah, thank you, Senator Corbett. It's an urgency measure. Candidly, we would have liked to move it earlier, but for a variety of reasons, we couldn't. The problem is if you walk back from the timeline, you have to amend your application, and it's not a simple process because we've gone through a full environmental review, and now you have to change the project. The project size is different, the type of technology is different, and while the environmental impacts are lessened, it still takes a lot of time and work to alter the application and the documents. So unfortunately, we're in a position where we need to move this as quickly as we can.
Okay, thank you.
Senator De Leon, followed by Senator Wright.
Thank you very much, Mr. Chair. This is open-ended question to all individuals, those obviously in support of the measure as well those in opposition. Given the intent of the measure itself and the fact, and you can correct me if I'm wrong, that an environmental review will be considered if this measure does pass and signed into law by the commissioners and staff of the CEC, what I'm trying to do is I'm trying to sort of wrap my head around the opposing arguments as to why the intent to kill the measure today in policy committee, if in fact, and again, let me state that I was not privy to any of the conversations nor any negotiations for those who opposed and those who support the measure. I'm seeing the letter in the Senate Journal for the first time today from Mr. Simitian. I wish he was here, but unfortunately, my understanding is that he may be a little under the weather. Again, if the process were to move forward, because the way I'm kind of looking at this measure right now is I understand your opposition, and I've read some of the data or the articles that Ms. Kehoe just let me read right now. This is more of a process issue instead of dealing with this issue in policy. If the measure were to move forward, go to the CEC for the review and the analysis, wouldn't there be an opportunity to weigh in and weigh in heavily at that juncture?
Yes, definitely you can petition to appear before the Energy Commission and participate with the Energy Commission. I think what we're saying here is that what we would like is that this project, because it's converting to photovoltaic, we would like it to go the environmental review route that every other PV project is supposed to go through, since we're now past the urgency issue with the RF funding projects and the DOE deadlines that we were all killing ourselves to try to meet at the end of last year, and that instead the project would go to San Bernardino for CEQA review, the Department of Fish and Game would review it for ESA, and the Regional Water Board if they had an issue. So I think we believe that the project would go through a review that we feel, frankly, at least from my perspective as Defenders of Wildlife works on biological issues, would get a better review and with more opportunity for us to have input in than through the Energy Commission proceeding. We did participate at the Energy Commission proceeding on the Calico project, and we weren't particularly happy with the way that because they're standing in the shoes of the Department of Fish and Game when they're, as an in lieu permitter, and we didn't believe that they frankly, did a good job representing the public trust resource issues. They're the Energy Commission. They're not, experts on everything. So we would prefer to see this project go through the route that every PV project has gone through.
The original project, and I know you want to weigh in, Mr. Mann, just bear with me one quick sec. The original project, which was put forth thermal, and they changed from thermal to solar PV, is it the same footprint?
No, not only is it not the same footprint, it's shrunk and it's created more habitat. And actually, we just went through a mediation process with the governor's office, Ken Alex, who runs OPR, to shrink it even more. So the project is changing, but we think changing in an environmentally positive way.
So the difference between thermal, if you will, and PV with regards to the environment itself and the habitat, and in this case, the tortoise, and I believe there was another particular animal that possibly could be at risk. I forget which one it is. I know it was in the article. With thermal and PV, is there a major difference with regards to what potential mitigation will need to take place with regards to the habitat?
The way that the project was configured before, there are definitely differences. The Stirling engine had a big block, and it wasn't a pole the way that PV is. So, and I think one of the bigger issues is flexibility in how you design. You've got more flexibility when you use PV versus thermal, and Mr. Gallagher, I'm sure, will let you know. Again, for our purposes, while the project may be getting smaller, the analogy I would use is if you were going to put a 10 square mile project in Yellowstone and then say, oh, well, it's actually only 2 miles a square mile project now, it's still in the middle of a really important area. So you just, the configuration, we appreciate the company talking to us, but when we started the conversations with them 3 years ago, it was with the urging that this was a very important biologically intact area, and that we really wanted them to try to move the project elsewhere, and we suggested other places to move. And unfortunately, like I said, we were able to work out issues with many companies in the desert, and frankly, we signed settlement agreements with First Solar and SunPower on the Carrizo project. So it's not like we're running around opposing every solar project out there. This is one that we've really, the impacts are too significant and cannot, frankly, be avoided or mitigated. We don't have a problem with the mitigation. Our problem is with the location.
Mr. Manning, the first question I'd ask is could you go back, because I know you wanted to contribute or add something or delete.
To be honest with you, Senator, I lost track of the first question.
Okay.
In terms of I think I remember now. I think the answer is, what's interesting about this is it makes it sound like the Energy Commission's just sort of an easy process, and quite to the contrary. You need federal permits and state permits too on a lot of these issues, including take permits, et cetera. So, and we have to go back and revise the environmental document, and we can be sued again. So that's the risk we have. And Mr. Gallagher can talk more about the habitat issues if you want to hear on the sides of the project.
Well, let me add just one last question. I just have one last question. In that, how many projects got this process granted in SB 226?
Yeah, I think it was 7, I believe.
7. So we have 7 projects, that have been
that are eligible.
That are eligible.
We may be the only one that really wants to pursue it. I'm not sure.
No, that's not true. The Solar Millennium Blythe, I believe, is going back and trying to reconfigure from thermal to PV, but the other ones have stayed with. And Imperial Valley Solar is not happening anymore because they ran into too many problems with the tribes. So everybody else, I think, is pursuing the technology that they originally proposed and are not going back to the Energy Commission. As far as I know, maybe Genesis is because they've got tribe issues as well.
Okay, thank you. Thank you, Mr. Chair.
Senator Wright.
We've had a kind of a circular discussion about what Senator Simitian intended. I don't know, Mr. Chair, if we have a deadline or a crisis issue, but why don't we, is there time to get Senator Simitian back and ask him? The letter doesn't really tell me anything because it doesn't specifically reference this plant. It doesn't say, I like this plant or that plant. It just says something that is written in Joe speak, which I don't quite understand. I didn't go to law school, but why don't we? Yeah, why don't? It's right. Yeah, it would seem to me that, we've probably invoked Joe's name at least 10 times since I've been sitting here, and the only person who's not here to answer is Joe. So why don't we ask Joe what he meant relative to this bill so that we're not speculating? I mean, it's clear.
Well, Senator Wright, while I appreciate that comment and suggestion, it reminds me of a concern that both Senator Kehoe and Senator Pavley have articulated about legislation benefiting or for the purpose of advancing a single project or a company.
Right.
What's before us is a process proposal, and if it, the project that we're discussing is eligible or it applies to or what have you, then so be it. I don't think Senator Simitian was legislating the approval of an EIR for this particular project. It was more a statement of process.
Yeah, I mean, again, just looking at that, I mean, it's clear that the opposition doesn't want the plant built. The suggestion to go find another piece of dirt, again, having worked on a number of projects before, that's a whole lot easier said than done, because I suspect that there's a cash investment that you've made in the dirt that you have, ordered, whether you purchased it or secured an option or whatever method that you took to gain access to that piece of property. And then assuming that you moved it, now you move into the fact that the environmental work that you did on this site is irrelevant to the new site, so that in effect means that you'd start out over and you'd incur significant cost. I get that and I understand. I think the broader policy question, and I think is clear, that non-thermal projects in general should not be at the Energy Commission, except this bill, as I'm reading it, only applies to your project with the narrow provision that because you started there and you made the transition, I'm not sure why you switched from a thermal to a PV. Presumably, if you stayed at a thermal, you could build what you have where you are, and we'd be having a different discussion. It would seem to me that your footprint would be smaller with the thermal than it would be with the PV, because with the mirrors, you'd end up needing less space typically, as you would focus the mirrors. I mean, PV's land requirements typically are much greater because you need surface area to generate the space that you created. But that's your business plan. That's not my problem. I mean, I would be inclined to vote. I would certainly feel more comfortable if the senator who we're discussing in his absence were here to add clarity to his feeling about this bill as opposed to what the intent of his language was.
Any other questions or comments?
I'd be careful, by the way. The price of gas, you're nowhere near the price of a combined cycle gas plant in today's gas price. So, I mean, yeah. I mean, gas today at NYNEX was running right around, almost at $2. You can't get nowhere near that in your best days. So,
is that an amendment, sir?
Yeah, we'll take that.
Well, and he hasn't even gotten to the point where are we still base load or not? No longer base load, but that's not for us to decide.
That's a procedural question.
Senator Pavley.
And the author can answer. So this is an urgency bill that requires 2/3 on the floor, correct?
That's correct.
On the floor. And it's an urgency. It's not because of loss of the ARA money, is it? Because that's...
No, it's because if you look at I think it's outlined well in the analysis. It explains exactly how the June 30th deadline, I think it's the last.
I think it has to do with a time frame for amending further the application before the Energy Commission or not, and staying on that track.
If the bill should pass out of committee, I'd be willing to continue to work with you, hoping that there may be amendment should it come to the floor and you are searching for 2/3 vote.
I will take that.
The other questions or comments? If not, Senator Rubio moves the bill. Let's call the roll.
Senator Padilla?
Aye.
Padilla, aye. Fuller? Aye. Fuller, aye. Berryhill? Aye. Berryhill, aye. Corbett? De Leon?
Aye.
De Leon, aye. DeSaulnier?
Aye.
DeSaulnier, aye. Emerson?
Aye.
Emerson, aye. Kehoe? Pavley? Rubio?
Aye.
Rubio, aye. Semidion? Strickland? Wright? Wright, aye. 8.
Okay.
Didn't you say you would vote for it here?
No,
That-
I said I would be glad to vote for it on the floor.
That measure is approved. I want to thank you all for the discussion. Clearly, we have more work to do.
Thank you, Mr. Chair.
In this space. Congratulations, Assemblymember Fuentes. If there's nothing further, this meeting is adjourned.